We're present in case 23 CR 500, State of Ohio versus James Carson. We're here on a motion to terminate community control sanctions. Defendant previously waived the probable cause hearing. Scheduled for a final hearing at this time. Defendant is here in court with counsel, Mr. John Fatika. Mr. Fatika, what's the defendant's intention at this time?
Good morning, Your Honor. Mr. Carson would like to waive his final hearing, accept responsibility for his misconduct, and resolve violations today.
Carson, you've been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated. Let me get this up here. You guys have a recommendation in the folder?
Sure.
Yeah, see one. Specifically, it's alleged you violated Rule 3, which requires you to report at such times and places as directed by your probation officer. And it's alleged you failed to appear on Tuesday, August 12th, Tuesday, August 19th, and thereafter. It's also alleged you violated Rule 4, which requires you to report to your probation officer the address that you are actually living. You're not to change that address without prior notification and approval of your probation officer. And it is alleged here that you were negatively discharged from Project Hope on August 4th, and you did not advise your probation officer of any other address where you were residing, and your current whereabouts as of August 20th were unknown. It's also alleged that you violated Rule 1. Rule 1 requires you to obey all local, state, and federal laws, and it's alleged on August 2nd.
The defense makes its strategy clear before the violations are even unpacked. Carson is not fighting the case. He is giving up the final hearing, accepting responsibility, and trying to move directly toward a controlled sentencing argument.
You were charged with no operator's license and operating a vehicle under a suspension. And then just recently you were convicted of that charge. Now, you have the right to have a final hearing regarding these allegations. That's a hearing where the state would be required to prove the actual merits of what they're alleging. You could have this final hearing, but you could also waive the hearing and plead guilty to the violation, the violations, I should say. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to advise you the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. It was originally 2.5 years. I extended it another 6 months the last time we were here for a probation violation, so I could extend it up to another 2 years. I can impose more restrictive sanctions, including an order that you serve time in the county jail, or I could terminate your probation and send you to prison. If I did that, it could be anywhere from 6 to 30 months in prison. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violation?
I'll waive the hearing and plead guilty to the violation.
Very well. As to the allegation that you violated Rule 3 by failing to report to your probation officer since August, what is your plea to that?
Guilty.
As to the allegation you violated Rule 4 by not providing an address where you're residing, what is your plea to that?
Guilty.
And as to the allegation you violated Rule 1 by having been convicted of a new offense while on probation, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Fatigue, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. The DUS, that is the basis of one of the violations, was resolved in Painesville Municipal Court. Mr. Carson served his 3 days on that. I received a telephone call from his cousin, Dalia Mackey, who indicated that Mr. Carson could reside with her at 7720 Sagamore Avenue in Cleveland, 44103. Mr. Carson has credit for 355 days time served. We'd ask the
That was
court.
358.
I'm sorry. What did I say?
You said 55. It was 61.
No,
And then the 3 days comes off of
Yeah,
that.
358, I'm sorry. We'd ask the court to consider all those factors in fashioning a resolution here.
Mr. Carson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Your Honor, I would like to apologize for being contempt of court, I would call it, not going to see my probation officer, and for me getting pulled over knowing I wasn't supposed to be behind the wheel. It doesn't matter what I was doing, I take full accountability for it. I was trying to make it to a good friend of mine's funeral that day. However, somebody was tired. She was also on Project Hope with me, and she asked me if I would take the wheel. She was sleepy from the night before, but I knew I shouldn't have did it. Like I said, I take full responsibility, Your Honor, accountability, I should say, and I never got a chance to. I think I might have seen the new probation officer. I only knew David Tompkins.
No, you had a chance. You didn't take the chance. You had plenty of chances to see your new probation officer.
Yes. And I kind of when I got the ticket was August 2nd.
It was a week after you were here in court.
Yes.
Refresh my memory. When he was here in court for the first PV, I gave him.
These allegations create a much bigger problem than one isolated mistake. Failing to report attacks, the basic supervision relationship, failing to provide a current address, makes supervision even harder because probation cannot effectively monitor someone whose whereabouts are unknown.
Like 30 days of TDR.
Yes.
So how was he out?
He did have a job lined up and he was living at Project Hope.
So he didn't do hardly. He got out pretty quickly after the last hearing.
Yeah.
Is there anything else you'd like to say, Mr. Carson?
No, Your Honor.
Mr. Tika, anything else on behalf of the defense?
Your Honor, I just wanted to have a clear record. I was under the impression that this case involved an F4 conviction. You mentioned a possible 30 months. I believe the cap would be 18.
Not for an OVI. Felony OVI, it's 6 to 30 months.
Oh,
And he
okay.
was advised of that at the plea as well.
Okay.
Felony for OVI, you can get up to 30 months in Well, this court has considered the pre-sentence report and investigation. I've considered the facts and circumstances of the underlying offense, the nature of that offense. I have considered the defendant's performance on probation. And I've considered everything that's been said here today. All this is considering the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, I'll incorporate all the findings I made throughout this case regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has failed to comply with previously imposed sanctions ordered by this court. One of those conditions is that he did pick up a new offense. So not only is the recidivism more likely it actually occurred. In this case, the defendant's criminal history goes back over 30 years. He's got 1, 2, 3, 4, 5, 6, This was his 7th OVI offense. He got a big break with the plea in this case to begin with not having a specification on this case. He's violated his probation once before for failing to report, and literally, I didn't even do anything to him really last time, and then he immediately failed to report again. I think a week after we were in court. And then he was gone for 6 months. And while he was gone, he was driving, that was early on, but one of the violations also was for driving a car with an OVI suspension from this court. At this point, it's clear the defendant is no longer amenable to community control sanctions. Prison is consistent with the purposes and principles of sentencing. Therefore, as a sentence to this court, then count 1, defendant served a term in prison of 18 months. He has credit for 358 days he's already served. I need to advise you, upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendants ordered to pay all costs. Were there any payments made on the mandatory fine that were ordered in this case?
No, Your Honor.
Well, that's still out. I'm not reimposing that. It's already been imposed. But that's still out there. Is there anything else?
The sentencing analysis becomes especially damaging when the judge turns to recidivism. A criminal history stretching more than 3 decades changes the entire risk calculation. This is not being evaluated as a short period of instability from someone with little history. The court sees repeated conduct across a long period, and the 7th OVI becomes a major indicator that prior consequences have not produced lasting change. The judge also emphasizes that Carson previously received a favorable plea resolution without an added specification. That detail matters because leniency is now part of the record against him. Every previous break creates a harder question. What evidence suggests another break would work? Sentencing courts are supposed to consider both punishment and future risk. Here, the history gives the judge a strong basis to conclude that repeated intervention has not prevented the same type of dangerous behavior. The decisive issue is not simply that Carson violated probation. It is that the judge concludes he is no longer amenable to community control. That finding effectively closes the door on the defense's preferred outcome. The court points to a previous reporting violation, minimal punishment, another rapid failure to report, months outside meaningful supervision, and prohibited driving. Taken together, those facts allow the judge to view community control as exhausted rather than unfinished. This is the point where leniency can actually hurt a defendant later. A judge who previously chose restraint can become more confident imposing prison when that restraint produces immediate noncompliance. The 18-month sentence reflects that shift. Carson receives substantial credit for time already served, but the court still imposes a prison term because supervision itself has lost credibility as a sentencing tool. The consequence is institutional, not emotional. The final orders show that the consequences do not simply disappear after the prison term is imposed. Carson receives 358 days of credit, significantly affecting how much of the 18-month sentence remains. But release can still bring another layer of supervision through post-release control. That creates a new risk structure. Violations after release can produce additional incarceration. The judge also disapproves several programs that might otherwise provide alternative routes through the prison system. That decision signals a restrictive sentencing posture rather than an effort to soften the result through specialized placement. Costs remain, and the previously imposed mandatory fine does not vanish simply because the court declines to impose it a second time. The broader lesson is severe. Repeated failure under supervision can steadily eliminate options. Once the court concludes that community control has failed, future freedom becomes more conditional, not less.